On Law Weekly today, some legal practitioners share their thoughts on how the tribunals have fared. On our interview segment, Senior Advocate of Nigeria, Femi Falana, is our guest. We'll be talking about the tribunals, the new INEC board, and what may have happened to the much speculated position of Attorney General of the Federation. Was he penned down for a cabinet position? We have all the details on this edition of Law Weekly. I'm Shola Sheyeli. Welcome to the program. Elections in Nigeria have always been a contentious issue, with politicians sometimes trying to outsmart one another by all means possible. After more than a decade and a half in a democratic regime, most elections in the country are still resolved at electoral tribunals, a development that sometimes puts undue pressure on the judiciary and exposes some of the judges to ridicule. An overload of litigations, pressure on electoral tribunals, and the moral and ethical implications of illicit interactions between tribunal heads on one hand and litigants are some of the consequences of this reliance of the political class on the judiciary to resolve election matters. The judgments coming out of the courts on disputes arising from the 2015 elections has once again brought these problems to the fore. While winners praise the judiciary, losers have been leveling allegations of bias and corruption against the judges. Law Weekly sought the opinion of some lawyers on this issue.
These judgments we are talking about do not emanate from a single panel of tribunal. It emanated from different tribunal. Kogi, Lokoja, Meduguri, Gombe, Ilorin, Ibadan, and so on and so forth. So, a tribunal will arrive at a judgment based on the facts presented before it. And you see, it's very difficult, and it is a disservice when you continue to attack judgment on the face of it. You have to read a judgment holistically, in whole, and see what are the points martial, what are the rationale for a court or a judge or a tribunal to come to a particular decision. It's only when those things are done that you cannot say, oh, there's a miscarriage of justice, oh, there's not a miscarriage of justice. And what are we talking about? We are talking of tribunal. After the tribunal, we still have Court of Appeal there. We still have the Supreme Court there. So there is avenue for you to be able to expose whatever you think is not beautifully done or is not done in a logical way or in a normal way. You still have the opportunity to expose it at the Court of Appeal. So the appeal is there. It's not for anybody. It's not for particularly lawyers or legal minds to just be attacking judgment just because of the few minutes they heard on the pages of or they read on the pages of newspaper, or the few time they were able to listen to it on television. No?
Try to remember the election of the one between President Buhari and Goodluck Jonathan, the first one, 2011. It was clear to most people that one way or the other, PDP won that election. It was clear. Even in Lagos, Dr. Jonathan won quite massively, and it was clear. Buhari came a distant second, 181,000 and all that. It was clear to people. So maybe one way of judging how sound judgments are and all that is the way people react, because they are the participants. They are the ones that voted. They will know. I know my friend, these people say, we've done elections before when someone like President Obasanjo will lose in front of his house. The last election that happened, President Jonathan lost at Aso Rock. And meanwhile, if you had visited Abuja months before the election, you will see only the banners of PDP. You hardly see Buhari, but people knew what they wanted. And I think our politicians should begin to learn to really understand what democracy is about. Democracy is not monarchy.
Welcome back. Let's turn our attention now to some of the top legal stories we are tracking.
We begin with the report that the Court of Appeal sitting in Abuja has dismissed the appeal filed by the Senate President, Dr. Bukola Saraki, challenging his arraignment and trial by the Code of Conduct Tribunal. The court threw out all 5 issues formulated by the Senate President. 2 judges out of the 3-man panel held that the panel lacked merit. A dissenting judge, however, upheld the appeal on the grounds that the CCT is not a superior court and the charges were not properly filed before it. The three-man panel, led by Justice Moore Abumain, held that the Code of Conduct Tribunal was properly constituted to try the Senate President. Counsel to the Senate President, Mr. Joseph Daudu San, says that the team will study the judgment and file its appeal to the Supreme Court. The federal government has preferred money laundering charges against the former National Security Advisor, Colonel Sambo Dasuki. This is in addition to the illegal possession of firearms charges earlier brought against him at the Federal High Court sitting in Abuja. Court documents showed that about $423,000 was seized at his home following a search. Colonel Dasuki pleaded not guilty when the amended 5-count charge was read to him, following which Justice Ademola Adeni granted him bail on self-recognition. To avert possible disclosure of the state secrets and other classified security information, the government also asked for a secret trial. The absence in court of James Ocholi San, one of the screened ministerial nominees, has stalled the trial of his client, a Nigerian-based Indian businessman, Patrick Fernandez, before a federal high court in Lagos. Mr. Ocholi had been defending the businessman and his 3 companies since 2008 on a 52-count charge of defrauding some Nigerian banks to the tune of 32 billion naira. The charge was preferred against the foreigner and his companies by the Economic and Financial Crimes Commission, the EFCC. The court had adjourned the case till December the 15th, by which time, he said, the issue of Mr. Ocholi's ministerial appointment would have been concluded. According to the charge sheet filed by the EFCC, the accused persons were alleged to have been between the 21st and 25th of January 2008 fraudulently presented to the banks various managers' checks for various sums. The River State Legislative Election Petition Tribunal has nullified the election of 20 out of the 32 members of the State House of Assembly. The 4 tribunals, in separate judgments, upheld the petition by the candidate of the All Progressives Congress (APC) for the elections and ordered reruns in the affected constituencies. The People's Democratic Party, the PDP, members of the House who are affected by the tribunal's verdict, including the Speaker, Honorable Owaji Ibani from Andoni constituency. The State Governorship Election Petition Tribunal had last Saturday voided the election of Governor Nyesom Wike and also ordered a rerun. The Supreme Court also dismissed the appeal that was filed before it by Governor Nyesom Wike, challenging the relocation to Abuja of the River State Governorship Election Petition Tribunal. In Plateau State, the Governorship Election Tribunal sitting in Jos, the capital, upheld the election of Governor Simon Lalong of the All Progressives Congress, the APC, in a ruling which lasted for 4.5 hours and which was delivered by a 3-man panel chaired by Justice Johnson Candide. The tribunal stated that all votes scored by the governor were valid. It dismissed the petition filed by the People's Democratic Party, the PDP, candidate Yang Pajok in the election. The Gombe State Governorship Election Tribunal also upheld the election of Governor Ibrahim Dankwambo. It held that the petition lacked merit. And we round off with the report that the appeal filed by former Deputy Speaker, House of Representatives and candidate of the People's Democratic Party PDP, Emeka Ehedioha, challenging the victory of the All Progressives Congress APC candidate, Governor Rochas Okorocha of Imo State, in the April 11 governorship elections, has also been dismissed by the Supreme Court. A 7-man bench led by Justice John Fabi affirmed an earlier judgment by the Court of Appeal, Owerri, which held that Ehedioha's failure to properly serve Okorocha and his party robbed the appellate court of the jurisdiction to hear the case.